Reforming data in criminal justice. That seems pretty straightforward. So as we did yesterday, I will introduce Amanda Woog, and she will introduce our fabulous panelists. So Amanda is part of our newest class of Quattrone Fellows. She joins us from the University of Texas at Austin, where she got her JD. And actually what brought her to our attention was some really stellar work she did with what is now called the Texas Justice Initiative, where she took a database, a public database, but not one that was particularly usable, of deaths in custody in Texas from a variety of governmental sources, and turned that data into a really amazing online resource that helps the citizens of Texas and elsewhere in the country understand what's really going on with safety issues for people who are incarcerated in Texas and their families. And it's that interest in and facility with data and how to apply data in the real world that I think makes Amanda a terrific moderator of this panel, and we're really looking forward to hearing what all of you have to say. Thanks.
Thanks, John. Good morning, everyone, and welcome to our panel, Reforming Data in Criminal Justice. Problems with data collection and publication have kind of run through each of the themes of this symposium so far, yesterday and through today, and so I'm excited that our panelists today are going to answer all the questions and solve all of the problems. So I'm Amanda Woog. I'm a research fellow here at the Quattrone Center, like John mentioned, and I'm so excited to have our panelists here today, Craig Futterman, Cynthia Conti-Cook, and Caroline Sarnoff, to talk about criminal justice data and their efforts to bring transparency and accountability to the system through data. To give you an idea for the format of today's panel, I'm going to briefly provide an introduction by framing the problem, and then each panelist will introduce themselves and their projects. The four of us will then have what I hope will be a conversation about the topic and our experiences, and then we'll open up to audience questions. And just as a reminder, there are note cards if you do have questions, to fill out the note cards and pass them to the middle. So it may seem obvious that problems in the criminal justice system cannot be addressed without adequate information. Information about the nature of the problem, its breadth, its depth, its causes, and its impact. Quality information is the foundation for good policy and governance, including by holding public actors accountable and by identifying creative solutions, like the ones we've been hearing about here at the symposium. So what do I mean by quality information? Well, as a start, and this is only a start, we need complete and accurate data collections that allow us to compare individual actors, groups, or jurisdictions, and which are publicly and widely available. Collecting quality data in the criminal justice system can be, put mildly, difficult. Though we speak of the system as a monolith, it's a highly complex, fragmented, and diffuse system. There are over 15,000 law enforcement agencies in the country, more than 3,000 jails, and close to 2,000 state and federal prisons. Data collected and kept by each of these institutions can be incredibly varied and idiosyncratic. Analysis across and even within jurisdictions is hampered by inaccurate or inconsistent reporting, outdated forms of data collection, and lack of uniformity in collection. And that's just to mention a few of the problems. Even where data exists, robust public access remains a problem. Our panelists will be able to fill us in further about the difficulties of obtaining criminal justice information, but as an initial matter, openness, transparency, and accountability are not exactly hallmarks of our criminal justice institutions. Many laws and policies protect policing and prosecutorial data from public view through restrictions on open data, or institutional resistance. More reform-minded agencies and offices come up against resource limitations without the personnel and budget to overhaul the data systems or build public-friendly websites. Even when data is published, it is frequently de-identified or published in the aggregate, precluding individual or agency-wide accountability. So the data problem I've briefly sketched is and has historically been part and parcel of our decentralized and opaque criminal justice system. But it really reached, in my opinion, our national consciousness in 2014 after Michael Brown was shot and killed in Ferguson, Missouri by Officer Darren Wilson. Reporters and researchers scrambled to find detailed data on how often cops would shoot or kill civilians. That was a quote from a Washington Post article on the topic. Seeking to contextualize stories of police violence, they were faced with the dismal state of national governmental data collections on killings by the police. And of course, as I've implied, the problem is not limited to lack of information on killings by the police, but this has become the high-profile lens through which we've been awakened to the issue. And personally, it's how I became interested in the problem. So in 2015, I was working in Texas when I came upon a large data set, thousands of entries of people who died in custody, police, jails, and prisons over an 11-year period. Amid the national conversation on the lack of information on police killings, I was surprised to find that Texas had been collecting this information for years under a state law, but that the data wasn't widely known about or accessed beyond a handful of journalists in the state. I decided to publish the data in an online interactive database and included the names of victims and the agencies involved. I'm really excited to have Craig here today because as I was working on my database, I was looking at his database a lot for inspiration and visualizations. In my experience, the problem was less that data did not exist, but more that it wasn't collected in a way that made it readily publicly accessible. The collection was not monitored either and suffered from compliance issues. I learned that there's a lot of dormant or diffuse data available about the system, but which hasn't been translated into public knowledge. And that's where our panelists today are transforming the data landscape. Our panelists are intervening to collect and publish data in a way that it can be used to spur transparency, public scrutiny, and accountability. Their data projects contextualize individual stories in the system and provide benchmarks for evaluating individual players and agencies. Caroline Sarnoff is the director of data outreach at Measures for Justice, whose mission is to bring transparency to the criminal justice system at the county level. Caroline is responsible for the design and implementation of MFJ's national data collection strategy, including outreach to federal, state, and county level criminal justice stakeholders. I could go on about her impressive bio, but the most important piece is that she received her master's in criminology from the University of Pennsylvania. So welcome back, Caroline.
Thanks. Thanks for having me.
Craig Futterman is clinical professor of law at the University of Chicago Law School and a resident dean in the college. He founded and served as director of the Civil Rights and Police Accountability Project of the Mandel Legal Aid Clinic since 2000. Craig and his students litigated for years in Chicago to obtain records of police misconduct, and after they won the lawsuit in the Supreme Court of Illinois, he worked with others to create the Citizen Police Data Project, which publishes the information that they obtained. And I encourage people to check out these websites because I just have screenshots, but they're very interactive. Cynthia Conti-Cook is a staff attorney at the New York City Legal Aid Society Special Litigation Unit, where she oversees the Cop Accountability Project and Database, leads impact litigation and law reform projects on issues involving policing, data collection, risk assessment instruments, and the criminal justice system generally. I just mentioned about 4 full-time jobs there, I think. The Cop Accountability Project and Database is a resource for public defenders in New York City and increasingly journalists for police misconduct information. And while the database is currently internal, Cynthia tells me that a public-facing database is in the works, and we'll hear more about the direction of the project from her. So I've asked our panelists to introduce themselves and their work by way of an origin story, how their projects of increasing access to criminal justice information came to be, their involvement in the project, and why this is the area where they've decided to focus their efforts. So Cynthia, maybe we can start with you?
Sure.
Thank you.
Thanks, everybody, and thanks for that introduction, and appreciating that my job feels like 4. So I'm in the public defender office, and I sort of have the advantage of being able to draw on information from all 5 boroughs, and including all 5 district attorneys' offices, and appreciate some differences in how cases are handled. But also, we have 1 police department in all 5 boroughs, And traditionally, there's been trends where one officer, once he comes to the attention of, for example, the Brooklyn District Attorney's Office, he might get transferred immediately after that to the Queens Borough. And in the past, this has worked really well for them, because then the Queens District Attorney's Office has no idea of any of the police officers' prior bad acts, and doesn't sort of do that sort of investigation into the officer's background until maybe the day before any of that officer's arrests actually go to trial. And so this was a sort of status quo of our general operating procedures when I started at Legal Aid in 2014. Now, the idea of a database, our former director of training, Dennis Murphy, when I arrived at Legal Aid with, like this commitment to build this database, left a 1992 typewriter typed memo on my desk that said, we need a database for cop misconduct. I think to gently remind me that this wasn't only my idea. And so I came in and there was separate Excel spreadsheets in every borough. But again, if that transfer from Brooklyn to Queens happened, there was no system for our Queens attorneys to know that this officer had previously been, for whatever reason, identified as unreliable by the Brooklyn DA's office. In some states, this sort of cataloging of information might not be necessary. New York State has a 1976 law called Civil Rights Law 50A, and it has two components. It says that officer information that is used for performance evaluation and continued employment should be considered confidential, and that personnel records are exempt from FOIL disclosure. It also has a provision heightening the standard of scrutiny for any litigators who are seeking the personnel records upon a subpoena. And so this means, according to the law and according to the Court of Appeals and how it's interpreted it, that defenders who are making an application for a subpoena must do more than just sort of appear to the judge and say, please sign this subpoena. They must actually apply an motion and meet two standards. One, that they have good faith to believe that this officer has prior misconduct that is documented in the internal records of the NYPD or in New York City, the Civilian Complaint Review Board, and that those records are relevant to our case. As you can imagine, it is difficult to argue that records you do not get to see are, one, existing, two, relevant. And so the best that we have been able to do in New York City in making these applications to the judges, we cannot FOIL the information. I've tried. I've gone through 4 lawsuits in the last 2 years. We cannot FOIL the information. So we have to do these Gissendanner motions, is what they're called. There's a similar purchase motion in California. And to make that good faith showing that this information exists, we put together the publicly known misconduct to the best of our ability. And our database has really existed in order to collect that material in a really easy to access way for our defenders. So this has been brought about simply by necessity, really. Our database is organized by the source of misconduct. It's a web-based application. We do daily polls of all lawsuits filed against the City of New York and the police department. We do daily scrapes of all news articles about police officers who have been arrested or police officers who have committed misconduct. And this has allowed us to put in the hands of our defense attorneys the information about police misconduct that typically they would not be getting, if they're lucky, until the day before trial. And as you can imagine, in New York City, not every case goes to trial. And so this is actually putting the information that our attorneys need in order to be able to correctly counsel clients about the risk of going to trial. And it has completely changed the dynamic in terms of our attorneys' ability to negotiate much more fair plea deals for a lot of clients. it has also put us given us the advantage of, even as early as the bail application, being able to argue that the prosecution's case is going to fall apart because they're relying on an officer who has committed the exact same type of misconduct as we feel like is happening in this particular case. So we've been able to expand this database. It was originally an internal database. We had 13 sources of information that we were collecting, which included attorney's notes, Brady letters, criminal court suppression decisions and incredibility decisions, lawsuits, news articles, social media investigations that we had done. We were able to take that and actually give access not to every source of information, like attorney notes, obviously not, to other defenders in New York City. So now we're all sharing a good amount of information about police misconduct together. And one example of the power of that happened about 3 weeks ago when one of our Brooklyn attorneys, when one of the attorneys from the Brooklyn Defender Office reached out to me about a cop who she was about to start a trial with. And this cop also was testifying in the Bronx because it was formerly a Bronx officer. And another attorney from our office in the Bronx was about to start a trial. And they both had been given different misconduct information by the DAs. And they were able to compare what they got, show the deficiencies to their respective DAs, and change the course of their trials by just being able to collaborate on that aspect of their cases together. So I could go on a little bit more about what is available and how we collect information and some of the challenges that we've had, but I'll leave that to questions.
Sounds good. I'm sure we'll get to that. Craig? Yeah, of course. I'll put your...
Amanda gave me permission to stand. Good morning.
Good morning.
Come on, people in Philly,
Good
don't say
morning.
good morning back. My grandma say it. Come on. As Amanda said, I direct a civil rights and police accountability project at the University of Chicago Law School. And what we strive to be is a ground-up, community-based law school clinic that focuses on police accountability and racism. Nothing too ambitious or anything like that. My hero, Randolph Stone, and I had this unfunded vision that became a reality now, many years ago, back in 2000. When we created the first law school clinic in the country that focused almost exclusively around issues of police accountability. And at the University of Chicago, which certainly wasn't your progressive bastion, and certainly not then. But our story, when I thought about this panel and Amanda invited me here, our story did not begin with reforming data in the criminal system. But it instead begins for us with a partnership we formed with residents in public housing in a high-rise public housing community called Stateway Gardens that made up about 8 square blocks of Chicago's South Side, situated just about 10 minutes from campus. Until the housing projects were torn down and entire communities disappeared, my students and I worked from the ground floor at Stateway as a part of a human rights reporting and advocacy project. And for many of my students, it became really their second home, their second base of operations for about 7 years. And to give you a sense of where this is, so the State Street corridor where Stateway sat made up the largest concentration of public housing and indeed poverty in the nation. This was about a 4-mile stretch of 10 and 17-story high-rises, towers filled with thousands of our nation's poorest families struggling to survive. And you could see that stretch of towers from this is typical, like the interstate, that divided public housing from the ethnic communities on the other side, like Chicago's own Soweto, a part of our racial divide. everyone who lives at Stateway, everyone who lived there was black. Residents trashed out for us at the beginning a vacant ground floor apartment that had been used as a dope house, and converted it into productive working space for us and for some other service providers. So for those 7 or so years, we were de facto squatters. We were off the lease, based ground floor apartment in public housing. We were never evicted though, almost. And so from that post in the ground, we experienced what felt like the operation of a completely different, a second constitution from what I and my colleagues taught in our law school classrooms, and a constitution in which police stopped, searched, treated our stateway neighbors as criminals simply just for being. And in that milieu, there were teams and teams of brutal and corrupt officers who thrived on beating folks up, breaking into their homes, stealing, harassing folks, shaking folks down, making Stateway feel like an occupied territory. And for us, so we felt like we were just banging our heads against the wall when we were trying to address these conditions. The police, as the people of Stateway understood all too viscerally, the police had all the power, and they had full command of machinery of institutional denial, secrecy. Everyone knew, and this is the thing about this in public defender context too, but everyone knew that the word of police would prevail over the word of any of our neighbors at Stateway. And officers would convey those messages every single day, that they were in charge, that they could do whatever they wanted in places like Stateway, and that there was nothing that any of us could do about it. Diane, we knew Diane. She was 50-year-old public school janitor, single mom, lived at Stateway, as a friendly face. And what I mostly knew her about was because I like to eat, and she could cook. And so she would always have, and there'd be that smell of food that she regularly cooked for her neighbors and people in the community. And then we just stopped seeing her over time. And I guess I didn't think much of it at the time, but we stopped seeing her. But that friendly face and the smell of that home-cooked delicious food just were nowhere to be found for a significant amount of time. And it turns out that over the course of about a year, a team of 5 Chicago police tactical officers subjected Diane to a series of repeated assaults on her person, her family, her home, and her religion. This group of officers, they were widely known in Chicago as the Skullcap Crew. They forced Diane on 2 occasions to disrobe, bare the most private parts of her body. They threatened her with a loaded gun, with needle-nose pliers, with a screwdriver, leaving her convinced that they were going to rape or kill her. They beat and they choked her. They assaulted her with racist and sexist epithets of the worst kind. They tore up her home. They desecrated religious objects that were sacred to her. They threatened to plant drugs on her and to falsely arrest her. And they beat her teenage son in front of her. And they even brought a middle-aged neighbor into her home and forced her teenage son to beat up the older man just for their amusement, like a staged cockfight. We learned that these 5 guys, these 5 officers, they'd engaged in a years-long pattern of doing this stuff to black folks in public housing. This wasn't anything new. We heard multiple firsthand reports of their abuse in addition to the sadistic stuff that I described with respect to Diane. And what distinguished them above all was their overt racism and the particular pleasure they seemed to take in their racist acts, like they got their jollies off of abusing black folk. And most of all, they knew that they could do it and nothing was going to happen to them. They had all the power. So to supplement the work that we were doing on the ground, the on-the-ground advocacy, human rights reporting, documentation, we said we weren't going to, even though we were lawyers in law school clinic, we didn't go there to bring lawsuits, but we wound up bringing a bunch of lawsuits. But we brought a civil rights lawsuit in federal court, both to redress the sadistic abuse of our friend and neighbor Diane, and also to try to expose some of the systemic conditions there that allowed it to occur. And as a part of it, and so here's where data began to come in more and more, as a part of it, we obtained 6 years of city data about every single complaint that involved police brutality and other serious abuse. And when we analyzed the data, we saw exactly why members of the Skullcap crew believed that they could abuse black folk in public housing with impunity. We learned that the police department refused to examine, to even look at patterns of abuse in black and brown communities, that the probability that the members of the Skullcap crew would ever be disciplined when charged with abuse was basically non-existent. It just didn't happen. That fellow officers would cover for them each time that they were accused of abusing black folks, and that the department's practices, their very practices for investigating police misconduct, were designed to ensure that nothing would happen, that officers like them would be immune, and particularly immune when abusing black, brown, and poor folks in Chicago. Even though we got all this stuff, and this goes to some of the challenges that Amanda was talking about at the outset, all this critically important information was hidden from the public. It was given to us under a strict protective order, a confidentiality order. And orders like the one that we got this information are routinely entered into on a daily basis by federal judges in civil rights cases. So as we fought for justice with Diane, we also spent another 2 years fighting this order in federal court, and there was an organizing effort on the ground that went along with this that helped to frame, it was really successful, and it helped to frame a public conversation in Chicago for about an 18-month period. Front page headlines were reading like, "What are they hiding?" The police chief was fired, mired up in scandal, replaced by, at this time, the first outsider to lead the Chicago Police Department since the 1960s at that point. There were a number of other like firings and public reform gestures. And we got the press, the New York Times and other major print media joined us in our legal fight. One of my favorite coups, and this was just really cool, and I don't know exactly how we did this, but we got City Council, and that's the legislative body for the city of Chicago. We got City Council to join us and to basically sue themselves. We got the majority of City Council members to say, shoot, we can't get the information, we need to supervise our police. And so they joined us in the suit. We get the city suing ourselves. So we win then, sadly, it's short lasting, but we win a really powerful ruling. In no small part, that came from the courage of a federal judge by the name of Joan Humphrey Lefkoe. And I guess let me share just a short backstory. I mean, a mentally ill, she's a federal judge, a mentally ill litigant who's in front of her on a case found Judge Lefkoe's home address on the web and then broke into her home through the basement when she wasn't home, and the man killed her husband and killed her mom. I can't even begin to describe or know her pain and her loss. And as you may imagine, when you think about police response, this is a federal judge. She got some pretty empathetic treatment and treated her quite differently than they treated my friends at Stateway. Notwithstanding this tragedy and the special care that she received, when sometime later she returns to the bench and she returns to oversee Diane's case, one of the first things that she did in Diane's case was to uphold that principle of open government. And one of the most elegant opinions I ever read, and I'm just going to read just a short quote that she said. She said, "Without such information, the public would be unable to supervise the individuals and institutions it is entrusted with the extraordinary authority to arrest and detain persons against their will. With so much at stake, the police simply can't be permitted to operate in secrecy." As I already foregrounded, her courage and sound reasoning was undone months later by our federal appeals court in a 40-page anti-press decision authored by one of America's most conservative jurists, one of the folks on President Trump's shortlist for the Supreme Court. But there was a footnote in this opinion, and my friend and colleague Jamie Calvin, who I was working so closely with, jokes, we drove a truck through that footnote, and the footnote read, "Nothing prevents the petitioner, us, from trying to get the same information under State Freedom of Information Act laws," the stuff that Cynthia has been banging her head against in New York State, New York City. So we took our fight to state court then, and we brought a Freedom of Information Act suit. And after a nearly 5-year fight, and I mean, some of this is just due to a lot of luck, but not just luck, but part of it, I think, an organizing educational campaign from the ground, we established a legal precedent in Illinois that police misconduct records belong to the public, belong to the people, including the identities of officers accused of abuse, the completed investigation files, all public. And I mean, that was historic. And as Amanda, though, said, it's one thing to win a legal precedent, and it's another thing to bring it home and to make it real. And so when we said public, we meant public. And there's this database. So we work with our community partners, a nonprofit called the Invisible Institute, to build this Citizens Police data project that's up on the screen right now. Publicly searchable database that gives everyone, when I say everyone, I mean everyone. This is open to everyone, ordinary people, researchers, folks languishing in prison, journalists, advocates, public defenders, lawyers, policymakers, et cetera, everybody with access to information about every single police misconduct complaint in Chicago. We recently won a related case before the Illinois Supreme Court, which helped us secure public access to every complaint, police misconduct complaint in Chicago from 1967 that exists to the public, to the present. I mean, when you think about that, I mean, this is a fundamental shift in a redistribution of power from the police to the people, to the public. Remember back at Stateway, and I'm going to end in 1 second, I'll start, the police have all the power. Just after we win this FOIA case in court, a Chicago police officer fires 16 shots into the body of a 17-year-old boy. 14 of those while the boy lay bleeding in the street. The boy's name was Laquan McDonald. As y'all know now, his execution was captured on video by a police dash cam camera. What happened though back then, people didn't know that. I received a confidential tip from somebody actually within law enforcement about this video, and we began a public organizing campaign to expose the truth. And at the time, very few folks, if anyone, was speaking out about Laquan, because when he was killed, he'd grown up in foster care, and the police falsely claimed that he lunged at them with a knife. Similar stories of police shootings occur in Chicago on a weekly basis. Indeed, we've averaged for about 30 years about one police killing a week. And I say police shooting a week. Police officers shoot somebody a week for about 30 years. So stories like those just appeared in the paper just as like a police blotter on a weekly basis, same old story. But folks finally and gradually began to take notice. And one of the things was when, back to Freedom of Information Act, we uncovered the autopsy, and the autopsy that also helped us to challenge the official narrative of a single shot in self-defense, 16 shots in a cover-up. And young black folk took the lead in fighting to lift the realities of their experience into broader visibility, and forcing really all of us to reckon with those realities. So my students, together with activists who were inspired by the Black Lives Matter movement, drew upon this same Freedom of Information Act work, the same data work, to win another court order that ultimately forced the police department to release that horrific video. And that video shocked the world. The entire world not only witnessed the unjustified killing, a murder of a black child at the hands of the police, at the hands of the state, but we also saw Chicago's code of silence, how this stuff operates. It's machinery of denial that's allowed this, not just single instance, but systemic abuse to take place with impunity in neighborhoods like Stateway Gardens as standard operating procedure. That jack can't be put in the box. So to close, data and information, powerful tools in creating the conditions for change, but those things just don't happen by themselves. Opening police departments don't automatically eliminate the racism, sexism, or Islamophobia within them. It doesn't automatically end the code of silence. It certainly doesn't guarantee fair, thoughtful, high-quality, independent investigations into police misconduct. And it also doesn't put an end to pattern of police abuse in Black and brown communities, much less the wanton killing of Black folks by the police. But it does create the condition to accomplish each and every one of those things if we act and if we make use of that information.
Thank you, Craig.
Yeah, thank you. It's
Caroline?
amazing work you're doing. I just want to, before I start, say that, Amanda, if someone, I think the way you framed this beginning conversation, someone should like frame it and put it on a wall, so if someone ever asks, like, can you explain criminal justice data in America to me? They'd be like, yes, it's right here. Like, you perfectly laid out all of the problems that we encounter every day trying to collect and standardize this data. So thank you for that perfect intro. I think I'll start by telling you a little bit about what Measures for Justice does and then why we do it. So we collect existing criminal justice data and we use them to populate a set of performance measures that look at the whole system from arrest to post-conviction, and we do this on the county level. So this is right here, what you're seeing is a visual of our online data portal. Pennsylvania was one of our first 6 states. And why we do this, I'll tell you about the origin story here. Our founder and executive director, her name's Amy Bach. She wrote a book called Ordinary Injustice, and in the book she tells the story of a woman named Sharon Pugh. Sharon was the victim of a particularly heinous case of domestic violence. She was beaten with a tire iron by her boyfriend, multiple witnesses, her nieces were there. She was admitted into ICU. There was, photographic evidence. She was in the hospital for a week. She was willing to testify. She did not. She wanted to press charges. And sort of everything you would need to move forward with a domestic violence case. And so when Amy was talking to Sharon, she said, so tell me about your case, what happened, did it go to trial? And she said, oh, no, the prosecutor declined to move forward with the case. And so Amy went to the clerk of court, and she'll tell you the story. Her name was Miss Wiggs, and she had a big gray helmet of hair. And, she said to Miss Wiggs, Amy said, tell me about domestic violence prosecution in Quitman County, Mississippi. Miss Wiggs said, I can't really remember the last time we had a domestic violence prosecution in our county. So she pulled out these huge, we're still on paper records in Quitman County, Mississippi. She pulls out these bound books and looks back and more books. And then she says, it's actually been 21 years since our county has prosecuted a domestic violence case. So then Amy goes to the prosecutor and she says, listen, are you aware that it's been 21 years? And he said, has it been that long? And for us, this was just this example that he kind of maybe had a feeling, right, that it had been a while, but certainly not 21 years. And it was because there were no sort of standard metrics or performance monitoring going on. It was sort of all of this data was tracked in these books. And so then we sort of thought, well, maybe that's rural Mississippi. Maybe they don't really move forward with domestic violence cases. But if you started to look at the counties surrounding, it wasn't that wasn't the case. Quitman County was an outlier for this sort of metric in the surrounding area. So at the end of the book, Amy says, we have mortality rates for hospitals, and we have test scores for our schools. But how come we don't have declination rates for county prosecutors' offices? And her whole point was we have an unmet need in our country, which is county-level measurement. The problem is no one really knows how well or how poor their systems are operating. And to even begin to undertake this seems just like an impossible monumental task. So MFJ really began in 2011. We sort of geared up in 2014. And I came on board to collect the data. And I was like bright-eyed and bushy-tailed, and I just wrote a bunch of emails and thought, surely everyone's gonna send me their case processing information. Okay, wrong. So then I just started getting in a car and driving around and having meetings and building relationships and talking about what we were doing. And, it's not rocket science, but suddenly I was having these conversations where not only with the public and the outsiders saying we need access to this data, the practitioners were saying, well, actually this would be really useful for me if you could take all of this raw data that's living in my computer and give it back to me as meaningful information. I would use that. And I can even think now, hypothetically, ways I would use that. So we started in 6 states. You can go on the website, but Washington, Wisconsin, Utah, Pennsylvania, North Carolina, Florida. We are on track to measure 20 states by 2020, and this is every county, okay? So it's not the San Franciscos and the Philadelphias and the Miamis. It's also, Pettis County, Missouri, and, small places, because the thing is these huge departments, they are looking at their data, right? They are making evidence-based decisions. They have a researcher, an analyst. But there's a gap in that access to smaller departments to use their data to make informed decisions. So Measures for Justice, our role in this is not as an advocacy organization or even a social change organization. We're really here as a data organization, right? We don't collect these measures and then rank people and give policy recommendations. We just give them something meaningful to then have a conversation within their department, within the community, about what this says on how their county level system is operating. Because as Amanda said, we do not have a criminal justice system in America. We have 3,000 plus criminal justice systems that all operate with their own autonomy and their own policies. And that's really how justice happens in America. So that's really the purpose and the goal of Measures for Justice. And happy to talk more, but I know we want to have a conversation. So I think I'll wrap up and we can.
Great, thanks, Caroline. So I want to pick up on kind of a theme that I think each of you has touched upon. Cynthia, you mentioned that the database can help change the dynamic in the courtroom, or even before you reach the courtroom. And Craig, you mentioned a fundamental shift and redistribution of power through the availability and accessibility of information. And Caroline, you kind of described how your data could empower both insiders and outsiders to monitor these institutions. So I kind of want to pry your brains a little bit more about this kind of power shift that we're talking about and what that looks like in real life. So how does access to data and knowledge help shift power, and what has that looked like in your own experiences?
Yeah, so an example that I really love to use is actually comparing Laquan McDonald's execution to Eric Garner, and how differently both cities responded in many different ways, because as soon as the video came out, I think it was timed, coincidentally perhaps, with the release of the database, and immediately journalists could look up the officer who committed the shooting and find out that he indeed had a long history of civilian complaints. And that immediately shifted the narrative in Chicago in a way that we had been struggling to shift the narrative in New York City. And so in our individual cases, we're trying to sort of shift the narrative inside each case, but there is a much more powerful public narrative about what is happening in communities of color and how police are acting in communities of color that does not get credited typically in the media. And having access to this amount of information has really changed the way that not just a judge in an individual case views, or a jury in an individual case views, like witness testimony, but when you can have a powerful example of Jason Van Dyke having a long history of civilian complaints, and that being known at the moment that this information is released, Jason Van Dyke was indicted. Daniel Pantaleo, who killed Eric Garner, was not. Jason Van Dyke was fired. Daniel Pantaleo is still on the police force. There was, even though I understand it's not perfect, there was systemic reforms or attempts at systemic reforms in Chicago because of this. And in New York, we're still struggling to even just get the information. And so I think that in the ways that the power can change are really, they're simple in a way, right? Just having more information gives you a better view of the full picture. And that is, of course, what in the criminal court system, the judge is supposed to do. The judge is supposed to be a check and balance on executive power, on police power. And that's why we have suppression decisions. But what laws like Civil Rights Law 50A have done is they completely limit the amount of information and therefore the amount of power the defense has in that context. And from the public perspective, laws like 50A and policies like the one in Illinois before Craig so brilliantly fought against it was publicly doing the same thing. It was preventing the public from being able to have a voice in democracy the way that we sort of assume that we do. We assume that we have all the information we need to make a lot of decisions. We don't even know there's a huge amount of information. I mean, like 30 years of police misconduct records that we haven't considered in determining whether our mayors are properly running our cities.
I'll just real quick. I'm going to take your question very literally, and we talk about power. And I think there is about electing people into positions of power. So when we are thinking about who our new district attorney is going to be or the new sheriff, part of that conversation should be how transparent and open are they with their data. For example, Kim Foxx, new state attorney I guess we were here yesterday, I'm a huge fan, but so Kim comes into office and creates the first ever sort of open transparency for all felony case level data in Cook County. Now, anyone in the future who wants to take that role is going to be accountable for the same level of transparency, right? They say, well, she made all the felony cases available. I have to be able to do that too, or I'm taking a step back. And anytime we're electing someone into these roles, this should be part of this discussion. This should be part of being in power, is that you are open about your data and the collection of that data.
Yeah, I mean, in part, I wanted to respond to some of Cynthia's comments because a lot of what you described in Chicago were firsts. And to the answer is like information is and was everything about that. So when you were comparing what happened to Pantaleo to Van Dyke, first off, that video was suppressed for more than 14 months. And so part of it then was releasing the truth about what actually happened, and then to show that this happened on a routine basis. And then, as you mentioned, then also with the release of the database, that people were immediately able to see that this officer had about 20 prior complaints, so much for brutality, involved in other shootings before, also for racial abuse as well. And it made obvious that, like, if we gave a damn and if anyone was looking at it before, that 17-year-old boy would still be alive. So it didn't just like, you know, it happened with the release of that information, and then a whole bunch of things happened as we were able to. So Kim Foxx becomes prosecutor. That's what happened. That's the biggest reason why the sitting incumbent prosecutor lost her job. And there was a hashtag Buy Anita campaign by folks at the ground, was that, yeah, you know that. Yeah. Was that her failure to address this and her failure to do anything and her sitting on this also for 14 months. But I want to put in perspective, so that prosecution and that prosecution of Van Dyke, I'm over 50 years old, and as I talked about, I've seen in the course of my life in Chicago, and I haven't always lived in Chicago, an average of about one police shooting a week. And one thing that hasn't changed over my lifetime in Chicago is that more than 3/4 of the people who've been shot by police, and this is are African American, are black, hasn't changed. But this was the very first time in my life that an on-duty Chicago police officer had ever been criminally charged with killing a black man, woman, or child. So yes, information, and then two other things just to add on to it in terms of just how does it make a difference in the real world. Then it also we petitioned and brought the Department of Justice, this is while still under the Obama administration, brought the Department of Justice to Chicago and forced them, and we tried to bring them to Chicago long before, but the political conditions on the ground made it so that they couldn't not come, and did what many describe as the largest civil rights investigation of a police department in our nation's history, and made the kind of systemic findings that people who I work with on a regular basis and generations have known forever, but actually now, no small thing, making them express findings of our federal government. Then came Trump, so it's a more complicated story, but this information, and then when used wisely, when used strategically by folks on the ground, social media, organizing, create the kind of potential for fundamental change that I'd never seen in my lifetime, and these possibilities are still real, and I think that data and information play a central role in supporting that.
I just want to add one anecdote to show how, to again contrast with that amount of improvement, at least up
We
until.
got a long way to go, but it's not.
But for sure, but if anyone's following what's happening in New York City with the killing of Shahid Vassell, they still haven't released the officers' names. For all we know, those officers are still going out on the street and going about their business routinely. The information that the NYPD has released on video has been edited versions of moments where Mr. Vassell appears to be, like menacing people with a, shower handle. And they've been extremely selective at editing and controlling the narrative of what happened. And the failure to release the names of the officers in New York City, at least, even with our not so good history with transparency, is unprecedented, and has been what a lot of activism in the past week has been around. It's just name the names, and so you can see how this issue, this control of information, is really escalating in New York City despite the presence of a so-called progressive mayor.
So it's not a coincidence that the three of you are working kind of outside of the criminal justice system. I mean, just the way that I thought about impaneling our panel today. And so, we heard Kim Fox talk yesterday about the transparency initiatives that her office is undertaking, and Larry Krasner here in Philadelphia is also becoming a lot more transparent than his predecessors. And so my question is, what do you see? I see a necessary role of outsiders, even with reform-minded prosecutors and law enforcement agencies. And in part, I think that has to do with the institutional constraints that I mentioned, having to do with resources and that sort of thing. But I think there are other reasons that kind of have to do with positionality as well. And that's just to kind of open up that question a little bit. How do you see your role as being an outsider to the system? I mean, of course, public defender, insider, outsider, I guess.
Outside.
But outside, how do you see your role as an outsider affecting the data that you choose to make publicly available and how you decide to publish it?
That's a great question. I think a lot of it has to do with just offering a helping hand a little bit. I mean, that's really how I feel at Measures for Justice, is if I could take one big lesson that I've learned the last 4 years, is that the state of criminal justice data infrastructure in America is awful. And that is what's informing our decisions, is this really messy data. It's not like that everywhere, but in a lot of places it is. And, it's in a lot of places, the mandate of maybe a local police department or a local public defender isn't to, buy a $500,000 case management system and then make that operational and train your entire staff on how to enter data. That is not their mandate. Their mandate is to defend people's constitutional right for an attorney. So there needs to be some outside help to make that possible. And, Measures for Justice, I think as we've gone around, when we started this, we thought, we're just here to collect data. And that mission has grown to, how can we provide technical assistance? How can we help them understand what data elements they should be tracking? How can we help them understand that this is important? How can we facilitate sharing this, And so I think it's not always about, can we pick out certain agencies or people and call them out for not doing things right, but really enabling them to move forward and come into a movement that's knocking on their front door, but they might not have the capability to really engage in right now.
And have never thought about their data that way, right? So
Yeah,
much of
totally.
So much of whether it's in the defenders or the prosecutors or in the court systems challenges with using their data the way that Measures for Justice has to really understand what is happening. That's not historically been the purpose of data in those systems. I mean, case management systems the purpose of that data collection has been to manage cases, to look at one case one at a time, and just sort of like have a more organized and facilitated view of all of your case history. When you start to ask your case management system about how many, gun arrests have been dismissed in the past year, you're going to find a lot of problems with your results if you start to really parse through one case at a time, because there might be mistakes in the way that the data was entered. There might be a lack of data entering protocol. It might be that you're not asking for certain pieces of information to be collected. So for example, we don't collect the bail requests made by ADAs at arraignments. Even though we've realized in the last few years that could be really helpful. But there's huge amounts of gaps in the types of data that's collected and thought about, because we haven't thought about generating reports about the productivity or the fairness or the efficiency of our criminal justice system really until you all came along.
Yeah, I would say I'll just add one little thing to that, which is sometimes I feel sort of naive because when we put out this data portal, I was like, yes, we did it. And no, because no one, I'm on the road a lot, so I'm meeting with these practitioners, and our executive director and our director of operations will say, what questions are you getting? The question I get the most is, how do I use it? And they're like, oh, they don't understand how to click. I'm like, no, they understand how to click. They just don't know what to do with failure to pay low monetary bail. Using big data is still new to a lot of departments. So for us right now, we're trying to create more, building up these use cases, helping people understand this is how you take a data portal and turn that into a conversation or action or something.
Yeah, I mean, we're working, I'd like to say that we're working toward being the outside help, but that hasn't been our reality.
Yeah.
And we are advocates, and advocates from the outside. When I say that's not been our reality, is that we've been fighting against official regimes of intentional secrecy. It's not that Chicago Police Department was saying, help us get out the names of the officers who've been most charged with abuse of people. Let's get out all this information about police misconduct. Let's show all these racial inequities in the criminal justice system or criminal system. And let's talk about mass incarceration. So we've been in the role of, first and foremost, doing and using data that should be public, that should be being used both internally and sharing, just in terms of the notion of what our democratic governance is supposed to be, is also access to information to allow the people and to actually monitor and see whether our government officials and actors are acting in the public interest. But what we've been fighting against have been systems that have created impunity for police abuse, particularly of Black and brown folks, and done so intentionally under regimes of secrecy, of fighting to keep information. So our strategies have first and foremost been, now we're moving more toward help too, is shoot, let's shame you into doing this. I mean, if this fledgling little nonprofit or little legal aid clinic, Invisible Institute, can show everyone what's obvious about, wow, here are a few percent of the force who are committing all this abuse and nothing's ever being done, and they're not identified, that it's so easy to identify that a 5-year-old could look at this stuff and say, here's where the smoke is and where you need to be looking. It shames them. I mean, we're talking about really we've been able to successfully show how much actual active work it takes by the public agency not to know about this stuff. They actually have to work not to know about the issues. So that's, and then we're trying then to advocate to then be the help. So then as we shame them into doing it, then you can be a leader instead of a follower. How's this regime of secrecy working for you? After this whole Laquan McDonald stuff, what do you think the state of trust is of the police and the justice system in Chicago? We have clearance rates for violent crime. We can relate it to prosecutor stuff. Clearance rates for murders that are less than 20%, and clearance rates for shootings that are about 3 to 5%, meaning that 95 to 97% of the folks who've shot folks are not being arrested, much less addressed, and are. So how's that working? How's that working for you? And imagine then, as horrible, even back to Laquan McDonald, as horrible as, and there's nothing that's going to make that anything less than an execution, but how would folks have responded differently if public institutions were honest from the beginning and came clean in the beginning and had a conversation about and called it out, held the officer accountable, not 14 months later after we forced them to, but said, let's address this from the very beginning. You'd have a very different state. And so we are moving, and now toward your help notion of, okay, if we can proactively create this database, let's take, because these are public data, you should be doing this, putting this up on the web in real time. Every time someone's stopped, every time someone's arrested, every time a use of force, every time a police officer uses force against someone, let's put up this information in real time and also put it in ways in which we can analyze, and so that researchers can dig into it, policymakers can dig into it, and we can help those agencies as well.
And from you, I'm gonna steal the "How's that working for you" line. I like that one. Yeah.
I would also just add that one of the signs of slight progress we're making in New York City has been that we've been hearing that the DAs, knowing that we have information on all 5 boroughs of officers, have realized that they need to start talking to each other as well. And so while I did not certainly intend for our role to be helpful as much as adversarial, because we're public defenders, it is becoming something that is turning into something helpful, where they realize that they need to start mimicking a lot of what we're doing. And as a result of that increased information sharing on the side of the prosecutors, they've also increased the amount of feedback that they are sending to the NYPD about, these officers, we don't really feel like we can put them on the stand. Could you please make sure they don't make any arrests in the future? And so eventually, it's very gradual, very incremental, but we do hope that we will be more helping the end problem ultimately.
Yeah, and also though, by doing it, and I mean by making these kinds of information public, you create the incentives and indeed responsibility of public and governmental officials to do it. And also we have a real live experiment. So, you can imagine the parade of horribles that if you made the identities of police officers who committed, or who were not even committed, because we won the case that if you're even accused and charged of violating the public trust, that's a matter of public concern. And all the horrible things that would happen. So we now have 3 years of live experience doing this, and guess what? The sky hasn't fallen.
Yeah.
All the horrible things that were predicted, if we did this, if we released this information, just never came true. And indeed, a number of positive things, some of which we've talked about, are and have been happening and creating the incentive for far more.
So that's a great segue into my next question. You've covered this a little bit just now, Craig, but I'll ask it anyway. There's also a question from the audience that came in about this too. But what should be the role of governments, local, state? We haven't even talked about federal, really, in collecting and publishing the kind of information that we're talking about. And in your jurisdictions, or where you've worked, what legislative or policy reforms do you think would help move us forward? Cynthia, I know I've heard about the laws in New York State, and I know, Caroline, that you guys have worked in Florida successfully recently. And that kind of goes to a related question, which Craig, you just touched upon and came from an audience member too. But how have your projects spurred greater transparency on the government side, for example, causing police agencies to release their own data? That was a lot.
Yeah.
Sorry.
I'll go real quick about Florida because it's super exciting. So Florida was one of our first 6 states. We populated the measures for every county, and Amy was contacted by a member of the legislature there. His name is Chris Sprouse. He's just like a young, brilliant former prosecutor, and he said, listen, this is great. I loved this beginning of data, but can you sort of tell me about what data you tried to get but that you couldn't? And it basically started a conversation that turned into a bill, which has now been signed into law, that mandates, and they actually ended up using almost every list of data elements that MFJ collects from every single, bucket of criminal justice agency. And it's created a law that requires all of these agencies to collect these data elements and then share them with a central repository where they will be stored, and anyone can access them. They're de-identified by the time they get there. We're still talking defendant level data, and to a level that's never been collected before, from prosecutors, public defenders, state courts, sheriffs, jails, law enforcement, all of that. So it's just really exciting because for us, we always say data begets better data, and this is like the perfect example, right? So we went in there, we collected what we could, and it started a conversation. So really, Florida is going to end up being the state that sort of revolutionizes criminal justice data transparency. I know, it's just we're really excited and we're really proud, I think, of Florida for moving forward and doing this. And I think it's not historical, so this is like a new requirement going forward. We should start to see it happening in 2019.
Without giving anything away, are you working in other states to have?
I don't know. I guess, yeah, we would love to see it in all 50 states. This is like the kind of work, this is exactly the sort of change as a data transparency organization we're looking to see. Our sort of hashtag is no data, no change. And sometimes people are like, oh, so you are a reform organization. You're trying to change something. No, change has a lot of different meanings across the system. For us, the change we want to see is something like this, where the government is really stepping up for open data, open information.
So this was like topic of dinner conversation last night. The PBA has, well, let me step back. We've been taking the shame campaign to heart that we have learned from Chicago and Craig. And we've brought a series of 4 different FOIA litigation cases, 3 of them against the Civilian Complaint Review Board for not releasing substantiated misconduct by officers, by specific individual officers. And we have 1 other case. So for 40 years, NYPD published summaries of disciplinary adjudications. So it'd be a short narrative, guilty or not guilty adjudications, but they were all based on substantiated investigations. And these were put on a clipboard outside the Deputy Commissioner of Public Information's office. And it was flipped through by reporters. And sometimes, they would report stories about these things. And this was the practice since 1972. That practice ended in 2016 when I foiled the last 5 years of those records. And we've been fighting that case. The day that we had oral argument last month, the city announced that it would be returning to publishing this information, but it would be redacting the officers' names. The PBA on Monday filed a TRO, and so that is happening. So we have, successfully shamed the city to a certain extent, realizing that this information absolutely needs to be public. They still are taking a very broad interpretation of the FOIL exemption to mean that they cannot release any information and therefore can't release names of officers. But again, I think that while we are successfully shaming them into at least pushing the chess piece, a little bit farther across the board in terms of opening up or returning, right? And this is not radical. It was 40 years practice. It was a practice under much more conservative administrations. But it is coming at, what it is really about, which is the unions pushing back. And that's what it's always been about for the de Blasio administration after the blue flu in December 2014. He's just refused to take any adversarial position against unions. And so that is playing out like as we speak in New York City.
And Cynthia, we got an audience question that's kind of related to this. Given the court's interpretation of CRA 50A, what's your strategy going forward? And what duties do prosecutors have to obtain disciplinary information from NYPD? Kind of touched upon these a little bit. But.
Yeah, so 50A is a FOIL exemption. The rule around FOIL is to release as much information as possible, interpret the exemptions as narrowly as possible, because really the public policy here is disclosure, right? And so our position has been that the police department and the city of New York has been doing the opposite. They've been saying, well, we're going to read this exemption really broadly and be really conservative about what information we think that we can release. But it's very explicit, actually, in the last part of 50A, that any department, including district attorney's office, special prosecutors, the grand juries, can access this information to use, for whatever government use they have. And making information public for the purposes of transparency is absolutely covered as a legitimate use of the information by the police department, by the city of New York. And so the argument that they are currently making that 50A prohibits them from using this information or from releasing this information in any way is just nonsensical. And if they were following their own rule, they wouldn't be able to answer virtually any pressed question about anything, including like the shooting of Mr. Vassell last week. And so they're really boxing themselves in by this I think I called it Frankenstein in an article a few weeks ago, this Frankenstein interpretation that's really just allowing them political cover with the unions. Now, as far as what we have to do to 50A to make it better, there's two pending bills in the Assembly. One is a modification of 50A and the other is a repeal bill. I absolutely believe we have to just completely repeal 50A. And again, this is not radical. We would actually be putting ourselves in better company. Currently, we are one of 3 states that has this level of confidential protection for police records. And we would be joining the majority of states that have just an unwarranted invasion of privacy exemption that covers police personal information. The modification bill is not going to do it because all it does is make the personnel record definition slightly more clear. It says you can not disclose information that is solely created for the purpose of performance evaluation. And that's highly problematic because right now the courts are already really loving this abstract, esoteric conversation about, well, what is the purpose of discipline if it's not for performance evaluation? And so saying that adding that language and modifying the bill slightly is going to change things is not true. And it was actually only introduced as an idea in the context or speculation of police departments saying body cameras were not going to be released. And not even New York City is making that argument. And so it's really, it's not going to do it.
Oh, so I guess to your question, the effect that this stuff's been having on public institutions, I think everybody saw that yesterday with Kim Foxx. That's the first time in the history of that office, the second or third largest prosecutor's office in the country that's going to be releasing for the very first time ever in its history lots and lots of data, including data that will reveal things about racial disparities and racial inequity and other inequity in the criminal system in history. With respect to, so in terms of even impact then on our city itself, so you've heard our story of constantly fighting against, so in Chicago having the earned reputation, so it's not that, wow, now it's funny when Cynthia's giving us credit or giving Chicago credit, but that's part of actually what we've tried to do is create political incentives, so you've been long known as the worst of the worst, and to transform yourself and to take credit for becoming a national leader when it comes to transparency. We're seeing that in Philly, what's happening with Larry Krasner, the release of the do not call list, similar list in New York, and there's also then, again, legal obligations that go along with it under Brady to release that kind of information. In terms of practical policy, and while from some folks' standpoint, some of this may sound pie in the sky, it really isn't. We're making some of this happen. It's just like where Amanda started the conversation with what moved you to first start thinking about this, how shameful it is that then as national attention turned to police shootings and police killings, that we don't even know how many people police officers shoot and kill every year. So it's just honesty demands that as a matter of national policy, not just 18,000 police departments, that everyone have to share information when a police officer shoots someone or is accused of brutality. Just simply being honest with people, let them know what's going on, keeping people informed, not lying, not hiding, releasing and having policy and law that requires the release of any related audio or video within 24 to 48 hours, and that's what the most enlightened departments are doing. We've gotten Chicago to write some of that in, not as quickly as I'd like, but to write that into official policy. And then same thing with respect to, and this is stuff that's been advocated for forever and yet it has yet to become a full reality, but to not just encourage like the Obama administration did, but to require each and every one of those 18,000 plus law enforcement agencies to keep track and publicly report information whenever a police officer stops, searches, uses force against someone, arrests someone, and to keep standardized data so we can compare departments across jurisdictions. I think it's that simple. That's, if you want practical things, what should be done by public agencies as a matter of policy.
An audience question that we got is about the institutional staying power of data initiatives. So there are many examples where data are released for a while, but ultimately the flow of data ends. How can we ensure sustainability of these efforts so that once Cynthia gets promoted or the DA changes, et cetera, we don't have the data cut off?
So I think it's about where the incentive lies to keep creating that data, which is why I think public defenders are such an obvious place to house, collect, manage, and make available police misconduct data, because we are the people in the courtroom who are supposed to be advocating for the judge to hold police accountable and to be that check and balance on police power. And we have the adversarial incentive to have as much of that information as possible because it serves our clients and it serves our communities. And so for me, I've been talking to a lot of public defenders across the country about trying to build up these systems internally. And of course, public defenders, as we all know and heard more about yesterday, are not well-funded offices. We aren't the $25 million defense team. That would be nice. But it is an opportunity and sort of a natural, you have the natural institutional incentive to collect and maintain that data. So I think it's about thinking through which institution is going to do this the best. And I think it's another reason why we're all outside of government and why it makes sense that folks outside of government are the people that have the incentive to collect this information. Governments have never, and I really appreciate how Craig framed his early work in terms of human rights work. Mm-hmm. I learned a lot when we were building our database from Patrick Ball from Human Rights Data Analysis Group, just in thinking about the challenge in documenting human rights violations that the government does not want to acknowledge, admit, let alone disclose. And thinking about police misconduct in that context, the government has absolutely no incentive to organize this information, to make that information available, let alone make it as visually amazing and accessible and understandable as Citizens Police Data Project has. And so we have to think about who is going to best be like the stewards of this data for sure, and make sure that whether it's Invisible Institute, that they are funded to do that and keep doing it, but it makes sense for it to be external to government in many ways.
So, I mean, well, I'm going to agree and disagree so as much as we've done as outsiders, to me, I think the gold standard is institutionalizing transparency as normal. It's just normalizing it. This becomes just what's expected by everyone, routine stuff, just as Chris Stone was talking about the very different norms in Britain, Wales, and our norms when it comes to prosecutors. It's about changing, and I think then, so when us outsiders, small fledgling public defender, underfunded public defender offices, one person then recruiting multi people within public defender office, doing the amazing work that you're doing, Cynthia, you know, do this and normalize and also show the power of this, and then it becomes routinized. I mean, and it becomes routinized and institutionalized by the agency themselves. That doesn't relieve outsiders and the public of the duty, the monitor, and the necessity of monitoring for all the reasons that you've said, but and checking and requesting ourselves and analyzing ourselves, but that it shouldn't fundamentally rely upon some nonprofit NGO that can be funded or not funded, sustained or not sustained, as politics shift and everything else. And I guess the thing, and I have a lot more hope and belief that it will be normalized, is that part of, once the jack is out of the box, you can't put it back in. And it's out there, and what also the kinds of systemic and fundamental problems and why this information is so necessary to have an operating and working system is beyond debate. I mean, we're beyond denial, and now now it's how do we institutionalize and make it normal for these things, for each of these agencies to do, and then check them and ensure that they do it. So yes, we brought in then when the Department of Justice left, so now we're suing the CPD and standing in the shoes of, we have Black Lives Matter and NAACP standing in the shoes of the Department of Justice in Chicago when what happens when the federal government abdicates its responsibility to do this stuff. But that doesn't mean I want to let the government off the hook. I want them to do their jobs.
So we talked about adversarial incentives. I would say incentives,
Yeah.
so money. You know, there are reasons that things like UCR and NCRP, the National Corrections Reporting Program, have higher rates of reporting, and because a lot of them are tied to grants and grant-making organizations, or grant-making federal organizations. So I'm not necessarily endorsing this, but I think that if we could tie data collection and open data to funding streams that are connected to that incentivizes people to build up the infrastructure to continue to collect this data if they're going to see, you know, a reciprocal money stream coming in at the same time.
Craig, you've mentioned in a piece that I read after your project launched, hoping to foster an ethos of sharing among lawyers. I don't know if you recall saying that, but that phrase kind of stuck with me, an ethos of sharing among lawyers, journalists, researchers, and others who come into contact with police records. And one thing that I've kind of noticed coming into academia just recently is that universities hold a lot of information on law enforcement and other criminal justice institutions that is not publicly available and doesn't intend to become publicly available.
Is that?
Yeah, so this is so counter.
There's an audience question that's kind of like a specific question related to that, but that's to just frame it just really quickly, and I'll get this in. But academics use research ethics, IRB, to protect subjects. Your work links abuse to people. Can you talk about the idea of data as accountability and what academics can do to name names? Are we legally vulnerable? Is a related question we got.
Yeah, so just as you said, so while what we're doing is kind of countercultural and countercultural in academia too, this ethos of sharing, so data is the coin of the realm for so many researchers and academics. And so what has been the reality that most of us don't want to admit is who gets access to data of academics, who gets favored nation status. The academics who get access to data from public institutions are those where it's not going to be an explicit deal. But if you use that data to make that institution look bad and to criticize them. So say Chicago, since I'll use Chicago Police as an example, if we're going to use this data to talk about the kinds of data that we've shared and analysis that we've shared about the issues of lack of police accountability and police misconduct, guess what academics aren't going to get access to the data?
Well, it is explicit too, because there are a lot of sharing agreements that require confidentiality.
Yeah, and a lot of times we justify, or academics justify, what we do morally on a regular basis in like, well, there's a lot of good that we can still do from this, a lot of knowledge, even if we can't go here. And so that is something that we very consciously and intentionally took on in the same ways that, and similar incentives historically have existed with respect to journalists. I mean, so the scoop is who gets to sit inside the police station? Who gets the first exclusive story? It's the journalist who's most friendly to whatever the institution is. That's how it's historically been. And so we're consciously seeking to challenge that, and also by creating also that ethos, or trying to build an ethos of that sharing, that we're producing knowledge. And, so by making the information that we've made publicly accessible, I want other researchers to write articles, to use the data, to analyze things, that it be used for public policy, that informs our decisions, and that debates things on all different sides of the issues. It's how we have more critically informed conversations, but by keeping a monopoly of data and also then using it explicitly or implicitly only for limited things is just, it's counter-academic, it's counter-educational, but it's stuff that we do all the time.
Yeah, and like I found a lot of times that sometimes when I run into academics who like have the data that I would love to have, it's that they've been they're in the state and they have contracts to do specific research. So maybe a body will reach out and say, listen, we want to look exactly at this, and then sort of built into that contract is a clause that says they can also use that data for their own research, but then they own that. So it's not like someone can come in and they don't operate as a clearinghouse, where then we can request it from them or something.
Mm-hmm. One thing, I've seen Brandon Garrett at UVA, he's come out with reports and simultaneously published data that he used for his reports. So I see that as like a possible compromise for some researchers who don't want the data to be public as they're working on it. They can publish it alongside the research so that other folks can use it too. I don't know if you all have any ideas for how to expand this ethos of sharing among researchers and journalists who are protective of the data.
And we're sort of on the flip side of this, right? So we've collected all of this data, and academics and other people are coming to us and they're like, wait, so you have case level data for 20 states? And so like we're on our end trying to figure out, we haven't shared anything yet because we do have data sharing agreements, but I think we would love to figure out a way of, we populate aggregate measures. How do we facilitate deeper analysis using all of this data we've collected? Because, we're not doing correlation and causation, modeling, we're not doing any of that, but we certainly have the breadth of data to do something like that.
So this is something, Craig, you and I were talking about a little bit earlier, but what do you think are kind of untapped data sources or sources of knowledge in the criminal justice system? So we've talked mostly about information that comes from within criminal justice institutions, or actually, Cynthia, I think your project might be a little bit an exception to this because you do kind of mine from other sources. But I'm thinking particularly about folks who have been impacted by the criminal justice system. How can we make them, how can we bring them into the conversation about sources of knowledge in the criminal justice system?
That's really, it's funny, so I've talked a lot about data, and I'm not going to dehumanize and call this knowledge just data too, but the bulk of our work is working with people, and working with people who've been most impacted by police violence, and even on the research side too, spent, for example, about the last 5 years just building conversations with high school students Black high school students in Chicago about their everyday experience with the police, not just this kind of like, just everyday stuff. And it goes to your question is just because the premise of everything that we do, the fundamental premise rests on that there is knowledge, wisdom, experience, and critical knowledge, wisdom, and experience that exist on the ground that is all too often absent both in our academic and in our public and public policy conversations. And I'm not going to deify or reify that, say, it's not real knowledge unless it comes from the ground. That's not really my point or my claim, but my point is that any conversation that we have that systematically excludes knowledge, perspective, experience, young folks at the ground we learn, are just young high school students, 16, 15, 14-year-old kids tell me every day stuff I don't know. Seriously. And there's stuff that we don't know. And if we're systemically excluding that information and that knowledge and that experience, not just tokenizing a voice, but as real knowledge, just as important as this quantitative data, if not more important, because much of this quantitative data that I've talked about simply, guess what, wasn't news to anyone who I've been working with for the last 20, 30 plus years. It's like, and isn't news to any public defender working with clients on a daily basis in New York, Chicago, Philly, Baltimore, anywhere else in LA, in America. But that it's sad that we need these numbers then to sell in academia, to sell public policy, sell other folks, because folks have systematically excluded knowledge and stuff that folks have known. So I guess the short answer is also that my point is that we're having a fundamentally bereft discourse or a not as fully informed discourse as we ought to be having when we're deciding policy, when we exclude that knowledge and information, and that we ought to be working awfully hard to ensure that the folks who are most impacted, not just their voices, but what they know, what they've learned, what we've learned together, is a part of informing our policies and our practices.
Yeah. I've definitely thought a lot about how to create a database for our defenders that has information far beyond the government documented misconduct that we don't have access to by way of necessity. And I also come at this, so there's that reality that I had to work within. Plus, I come at this work prior to being at the Legal Aid Society from the perspective of a civil rights attorney. And really the process of looking at officers' histories came from exactly that. I had yet another client come in battered by the same two officers from an anti-crime unit in the 67th precinct. And I was just like, all right, this is like at some point, someone's going to realize that these two officers have, and then of course I looked them up on the PACER federal database, have 7 lawsuits together battering people. And why isn't this raising red flags for the city of New York? And the answer was, at that point, and still to this day, although there's slight changes happening, the police department refuses to consider lawsuits, so documented misconduct in lawsuits, as being something they will make any decision about that officer on at all. So they are completely sort of sticking their heads in the sand and saying, if it wasn't an Internal Affairs Bureau investigation, a Department Advocate Office prosecution, a Civilian Complaint Review Board complaint, we don't have to take any action on it. We don't care that this officer has single-handedly cost the city of New York $500,000. All we care, in like 8 lawsuits, all we care about is the internal documented misconduct. And so that made us think a lot about like taking apart this monopoly of government information in terms of what they can act on as misconduct information. So we include lawsuits, we include criminal court suppression decisions, right, which is another way of documenting misconduct. And we've really thought about all of the ways that there is publicly known information about misconduct that we don't have to be subject to to the laws that the government creates about the misconduct information it collects. And so I think it's a really important part. There's also a few projects that have popped out of this sort of necessity, which are similar to mine, but the open police complaints, which I don't think has gone live yet, but is an opportunity. It's like TurboTax for police complaints. They walk you through a routine intake process for any civilian complaint review board or for any police complaint. And then at the end, you have the option to say, I want this information public. Or these are the restraints on my information that I want you to have. And then you can forward that complaint to the relevant government agency. But you can also just know that that information would also be publicly available in reporting that they do later, or they can actually have the choice to forward it to a local agency that would collect that information. And so projects like that are really expanding the scope, right? Or expanding the types of opportunities that people have to document government misconduct in such a way that the government doesn't continue to control how that information, what is happening with that information. And I think that's really key. And technology has been really helpful for that, right, in a lot of ways. And so I think that's expanding more and more. And like with your project even, right, the government was sitting on this information. They'd had it since, what, the 80s? And they just weren't making it accessible. And that's not a mistake. It's not information that anyone in government typically has a political incentive to work hard at.
Just to close out, I have one final question, which is, could you all maybe give us a preview what the future holds for your projects? And also if you have any advice to folks in the room who might be interested in having transparency projects as a piece of their work. I know you can't really explain what it took to get yours off the ground, but maybe some tidbits, how to think about working through that.
Take a data analytics course. It helps a little bit. So we are hoping, we have, like I said, 13 different sources of information in our database, and several of them are public, including lawsuits. And we actually are able to do the most amount of sort of coding on lawsuits, so distinct details about each lawsuit that give more information about where police misconduct is happening, what police misconduct is happening where. And so we're working on a public-facing website about, mostly populated by those lawsuits. And I mean, how we built it, we've had a lot of help. Patrick Ball at Human Rights Data Analysis Group, as I said, was hugely helpful in just helping us think through how to create a database that preserves, how do you say this, that really preserves the integrity of each piece of information and doesn't over-codify it or add too many, drop downs to it so that it just looks like a spreadsheet. But we've really kept it based on open narratives, really to preserve the person's statement about whatever has happened. But at the same time, making it very accessible. So we've worked with a lot of consultants. We've really relied a lot on universities that have clinics, whether they are tech clinics or like a combination of tech law clinics that really want to start making these projects and making more data available to lawyers. So yeah, that's a common. I'm happy to talk to anybody that wants to get into the real ugly details of choices that we've made about the data, but those are major takeaways.
Yeah, I guess I'm not going to get in the weeds so much. I mean, what we've done has been incredibly organic, and we're going to keep on. That's what's got us here, and that's what we're going to continue to do and build upon that, and direct our work toward what folks most tell us that what we learn is most needed. But I guess the biggest lesson, if I was going to think about, the biggest lesson or my takeaway is that this change, isn't going to occur by itself. We got to use this stuff, and it's really using some of what we built and building on it. And that's where I think I'm more inspired by young folk than anyone else, because young folk have used these tools and spread this information through social media, organizing campaigns, forcing us to reckon with realities of systemic police abuse and their everyday realities. And even with the present backlash, still seeing positive change in that direction. And I guess where I see the biggest challenge, or where we've experienced the biggest challenge, is just one of empathy. It's one of giving a damn. So I think we've made tremendous strides toward, and led by young folks, of making what has long been denied undeniable. But it's still, do we collectively as society give enough a damn about it? I mean, as long as police brutality and practices like stop and frisk are concentrated in communities like Stateway Gardens, as long as the primary cost of our various wars on crime, drugs, and whatever are borne by folks of darker hues in places that we quote unquote know to be dangerous, hell, still most white people who I deal with, and included, even if I'm gonna be honest, all too many relatively privileged Black and brown people have not cared enough to act on this information. And so to me, that's where the real challenge lies. I mean, one of the things that struck me just last week, I don't know how much if this at all made, it probably did make national news. Last week, for the first time on my campus, a college student, University of Chicago, was shot by a campus police officer. And this is the first time that that's happened in history, in the history there. But and there's a lot that can be talked about, but one of the things that's most stood out to me was, damn, and they shot a student who was in a mental health crisis, was that this could happen to us. And suddenly around campus, and actually this shooting may not even be unjustified, but suddenly it felt personal to so many people who see this stuff on the news, but haven't had to experience it, or the people who are the closest to them experience it as part of their lives. And I think that's really the challenge of how do folks much more broadly care. Now, having access to the knowledge, it being out there, are we going to act on it?
As far as where we're going at Measures for Justice, we're really working on expanding to cover as many states as we can. So measuring 20 states by 2020. In there includes California, which is a fascinating state, huge state, so many major criminal justice reforms in the last 5 years. They do not have centralized data. Every single county, every single agency has its own case management system and its own ways of collecting that data. So we're going county to county over the period of about 2 years, meeting with all those people. We're also investing a lot on the tech side of things. How can we scale this process? How can we automate the cleaning and coding to make this go more quickly, building a second version of the portal? We're also going to be developing a lot of user experience, like I talked about, helping people understand how to use a data portal and data this way. And then I think we'll hope to continue to educate legislators about about criminal justice data transparency. And my advice for people would be who want to do this is to play the long game. You don't have to be Kim Fox and release every single felony case for 6 years. You can be vocal about a commitment to open data, and then you can, walk the walk and slowly release more over time and build the infrastructure to do it on a continuous basis.
Well, I just want to thank the panelists. It's been a real treat for me and for the audience, I'm sure.
Thank you.
Thank you.